Welcome everybody to episode 4 in our SOPtober series. We started off the month by talking about payment claims. We moved on to a discussion about payment schedules. Last week we discussed adjudication, and now we're going to talk about the adjudication determination and enforcement. For those who don't know, I'm Matt Bryan, a special counsel here at Morrissey Law and Advisory. I'm joined this morning by Pat Ireland, one of our senior associates.
Morning, everyone.
And so for the next half hour or so, as I said, we'll take you through the process, starting with what happens when you get your determination, and then what you do about enforcing it if the other side doesn't agree to pay. So to kick things off, in terms of how long it takes to get a determination, the Security Payments Act requires all adjudicators to determine matters as expeditiously as possible, and within 10 business days of an adjudication response being provided by the respondent, or if, for example, the respondent hasn't put on a payment schedule and isn't entitled under the Act to put on an adjudication response, there's a requirement that the determination be issued within 10 business days of the adjudicator accepting an appointment. So it all happens very quickly, much more quickly than would be the case if court proceedings were commenced. In some circumstances, the parties can agree to extend the time within which the adjudicator can issue a determination. That will usually happen at the adjudicator's request, and in particular in matters which have some complexity about them or involve claims made up of many different items. For example, variation claims and things like that. If it's going to be a situation where the adjudicator can't physically go through all the material and come up with a proper decision, he or she might ask the parties to extend time, and that can happen by agreement. So once you have your adjudication, in terms of what that looks like, just moving on to the next slide, Pat.
Yeah, so the next big thing is what questions will the adjudicator actually answer in their determination? And the first one is the amount, if any, that's payable by the respondent to the claimant. Obviously it may be a $0 result, or it may be a positive result. The due date for payment, which will be the earlier of any due date that's in the contract, or the maximum payment terms under the Security Payment Act, which for payments from principals to head contractors is 15 business days. For payments by a head contractor or a subcontractor to another subcontractor, that's 20 business days. So the earlier of that, or the date under the contract. The applicable interest rate on any amount that is due to be paid, which will be the higher of whatever rate is stated in your contract, or the rate prescribed by Section 101 of the Civil Procedure Act, which sits 6% above the RBA cash rate. So it's currently 6.1%. A big thing to note that a lot of claimants are sometimes worried about is whether or not they can be required to actually pay an amount to the respondent. So if the respondent in their payment schedule has an offsetting claim that exceeds, an offsetting, I suppose, defense, which exceeds the amount being claimed, the best result a respondent can get is that they do not have to pay any amount. There can't be any, the adjudicator will never make a decision that the claimant has to pay the respondent an amount.
In terms of what the adjudicator takes into account, the Act sets that out quite clearly. So obviously the provisions of the Act itself are something that needs to be considered. The contract that's the subject of the claim, the dispute. He or she will take into account the payment claim and duly made submissions and any documents relied upon by the claimant, the payment schedule and duly made submissions and documents relied upon by the respondent. And if it's a situation where the adjudicator has elected to inspect the site where construction work is taken place in order to get a better idea of some particular aspect, the adjudicator can take that into account as well. It's important to note that reference to duly made submissions can sometimes have some real significance, and we'll come to it later on when we discuss the circumstances in which adjudications can be set aside. It's often the case that a party who's dissatisfied with the outcome of an adjudication and wishes to challenge it will make an allegation that submissions weren't duly made and should not have been taken into account. But essentially what it boils down to is whether or not, in particular on the respondent side of things, issues have been appropriately flagged in a payment schedule so as to entitle the respondent then to go on and make those submissions and expand on them in an adjudication response. So again, it's a theme of this Act that things have to be done quickly, but it's important to check all the boxes and make sure that there is strict compliance with the Act. Otherwise, there can be adverse consequences.
So once you've the adjudicator has determined the adjudicated amount, payment of that amount must be made within 5 business days of the determination being served on the respondent, or a later date that's determined by the adjudicator. In circumstances where the respondent fails to pay the adjudicated amount, the claimant, there's a few steps that the claimant can take. Requesting an adjudication certificate in order to enforce that adjudicated amount as a debt. And another great tool that can be used is a notice of intention to suspend work, which can be a really helpful tool to leverage that payment to be made. An adjudication certificate, once you've requested that from the adjudicator, it will contain details of the parties, the adjudicated amount, and the due date for payment. It can also specify the amount of interest payable up to the date of that certificate, and any amount of the adjudicator's fees which are determined as payable by the respondent, which have already been paid by the claimant in order for the determination to be released.
Once that adjudication certificate is made available, it can be filed in court as a judgment. And you see on the slide there a reference to a court of competent jurisdiction. Essentially what that refers to is the court that's appropriate for the filing of the document, taking into account how much is in issue. If there's a debt up to about $100,000, the filing will occur in the local court. Between $100,000 and $750,000, it occurs in the district court. And if it's above $750,000, then it can be filed in the Supreme Court. When it is filed, there's a requirement that it be accompanied by an affidavit from the claimant, or if the claimant's a company, the director of the claimant, confirming that some or all of the adjudicated amount remains outstanding, so that the court can be satisfied that there's evidence entitling the claimant to a judgment. And importantly, if the respondent subsequently attempts to try and have that judgment set aside on the basis that there's some irregularity with it, the respondent will be required to pay the unpaid portion of the adjudicated amount into court as security, so the claimant can then be satisfied and the court can that the money's there and available pending the outcome of the decision. If the claimant is successful, it will be released to the claimant. If the respondent's successful, obviously it'll be refunded. And a respondent won't be permitted to raise any defence concerning matters arising under the construction contract. They won't be permitted to challenge the adjudication determination and attempt to revisit issues that have already been determined by the adjudicator, and the respondent won't be entitled to bring any cross-claim. So again, we'll talk about this in a few slides' time, but there are quite limited bases upon which adjudication determinations can be challenged. And it essentially boils down to a failure to adhere to one of the strict requirements of the Act, and a lack of jurisdiction really on the part of the adjudicator. So the Act is set up obviously to promote cash flow and ensure that claimants can be paid in a timely way, and it would frustrate and undermine the whole basis for the Act if respondents could continue to sort of put up roadblocks and make it difficult for claimants to enforce a right to payment. So, having said that, moving on to the ways in which you can enforce the judgment debt once it's registered.
So once that judgment debt is ordered by the court, and unless it is set aside or varied by the court, then you'll have, assuming that you're the claimant will have 12 years to enforce that judgment debt. And there's a number of ways this can be done. Under typically a great place to start, particularly if you're unsure of what kind of assets or the financial stability of the respondent or their ability to pay. A great first step can be to issue an examination notice, which provides a period in which the respondent will have to front up and provide a bunch of financial information, which essentially gives you an idea of if they've got any money lying around and where might be the best place to go to chase that money. You can, if you need to take it a step further, if payment still hasn't been made, may apply for a writ of execution, which involves the sheriff visiting the respondent and seizing and selling property owned by the respondent or the debtor in this instance. Applying for a writ to be registered over any real property, so any buildings or houses or anything like that owned by the debtor. Issuing a garnishee order is also another great step to take. Once you've got an idea of whether they've got any money floating around in a bank account, or often just to see. To have that sort of first stab at chasing the money. Basically, once a garnishee order is issued by the court, it then needs to be served on the debtor's bank. And if there is any money sitting in the account that is the subject of the garnishee order, then that amount will be removed from that account, and you'll be able to recover that essentially. If the judgment is registered in the district or the Supreme Court, you can also seek a charging order, which freezes any dealing by the debtor in shares owned in a public company, bank accounts, or equitable interests in property. If the judgment is registered in the district or Supreme Court, you can also seek a sequestration order over property owned by the judgment debtor. And if you're in the Supreme Court, you can seek the appointment of a receiver over the income of a judgment debtor, or a sequestration order over property owned by the judgment debtor.
Yeah, I think it's really a case of picking your remedy based on how much is owed. Obviously, if it's a debt that's a couple of $100,000, it's possible but unlikely that the other side will have that much, sitting in the bank available. So a garnishee order might not work well in those circumstances. A charging order, for example, might be a better way to go about it, or the examination notice, as you said at the outset, Pat. It's a good way of assuming there's compliance with it, getting a snapshot of the other side's financial circumstances, and that as well can help you make some better decisions, some more informed decisions about enforcement. The other way you can go about it in certain circumstances, which didn't make it onto the slides, which is as relevant, it's by making an application under the Contractors Debts Act, particularly if there's a hierarchy in the contractual chain. If you're a subcontractor, you're making a payment claim, and you know there are one or more parties sitting above the other side of the adjudication in the contractual chain, including the principal. In some circumstances, you can make an application under the Contractors Debts Act, which will result in parties further up the contractual chain having to pay money directly to you and bypassing the respondent to the adjudication. So that will involve invariably an application having to be made to the court, whether it's the local, district or supreme. But it's worth bearing in mind, particularly if a payment withholding request has already been made, which I think we talked about during last week's session, and money is being held by someone further up the contractual chain. It's a good way of enforcing payment in the event there's some difficulties. The other way you can go about doing it is by issuing a creditor statutory demand, although there's some case law which suggests that might not always be an option. It's generally a good way, and often the best way, particularly if the amount of the debt is substantial, of putting pressure on the other side to compel payment. Normally, a failure to comply with a statutory demand will give rise to a presumption of insolvency on the part of the other party, and that in turn will permit an application to be made to the Supreme Court for a winding up order and for a liquidator to be appointed to the other side. So, as I said, if the other side wants to avoid that happening, it needs to come up with a solution. It's obviously a good way of applying pressure, but there can be difficulties in enforcing by way of a creditor statutory demand under the Security of Payments Act, and primarily that's because the Act is set up to deal with rights on an interim basis, not necessarily a final basis, and we'll talk about that in a little bit more detail in a second. But the courts have recognised that if there is a genuine offsetting claim, that can form a basis to allow a respondent to resist having to comply with a stat demand and ultimately avoid a scenario where they're faced with a winding up summons. So there's a problem, obviously, with a respondent trying to challenge the genuineness of the debt. So that's slightly different. That they're not permitted to revisit the adjudication determination. But if there is a genuine offsetting claim, that's a different story. And you see on the screen a reference to a case in the matter of Douglas Aerospace, a 2015 case in the Supreme Court. That's authority for the principle that a demand can be set aside if there is a genuine offsetting claim, and it was reinforced in another 2015 decision, J Group Constructions. And just to sort of better illustrate what we're talking about, just to give some practical examples, you see there's a few cases that are referred to on the bottom of the slide there. The first one, AJ Richardson Properties and Segbor, was a case where an adjudicator had issued a determination in February of 2009 requiring the respondent to pay about $270,000. The respondent wanted to make a submission to the effect that it had overpaid the claimant to the tune of about $10 million. It was, I think, a $16 million contract. But because they hadn't made that submission in their payment schedule, they were barred from raising it in the adjudication response. And that's why the claimant, it was the most obvious reason why the claimant was ultimately held to be entitled to that $270,000. Pretty much straight away after the determination was handed down, the respondent commenced proceedings seeking orders in relation to the alleged multi-million-dollar overpayment. And it served, that happened on about the 19th of March, so 2 or 3 weeks after the adjudication determination was handed down. And the claimant, in response to that, subsequently put on a stat demand, served a creditor's statutory demand, I think a couple of weeks after the statement of claim had been served. So at the time of the issuing of the statutory demand, the claimant was aware that the respondent was suing it for $10 million because it had said that that's how much it had overpaid the claimant. And notwithstanding that, it put on a stat demand. So the court ultimately said that in those circumstances, the statutory demand was essentially used as a debt collecting tool, and that's not an appropriate use of the stat demand. It was more about enforcing debts where there was no sort of genuine dispute or genuine offsetting claim. So that's one example of a situation where a claimant couldn't go full steam ahead by way of the statutory demand process. The second example, Kershaw Superannuation, Pty Limited, and C&L Building. Again, a judgment of a fairly sizable amount. I think in this case about $255,000 was entered against Kershaw following an adjudication certificate having been issued. C&L issued a statutory demand to try and enforce payment of that amount. Kershaw argued that it had a genuine offsetting claim because there were defective works that C&L were liable to it for. Kershaw put on an affidavit suggesting that the cost of rectifying those defective works was about $245,000, so almost the same amount as the judgment that the statutory demand was seeking to enforce. And the court held in that case that Kershaw had established an entitlement to at least mount an argument and pursue a claim for the $245,000. Kershaw had gone away and commenced proceedings in the district court. And in that case, the court, instead of just setting aside the statutory demand, it varied the amount of it. So essentially, it subtracted the $245,000 that Kershaw was saying was the cost of fixing up the defective works from the judgment of $254,000, and C&L was ultimately entitled to the difference was about $8,000 or $9,000. So again, a situation where even though you might have a judgment based on your adjudication determination, you can't necessarily go forward under the statutory demand process if there is some genuine offsetting claim. The final example worked in the other direction. The situation was that there was a debt of about $60,000 that had been claimed by way of a statutory demand by a company called Lightning Electrical Group. The debt related to electrical works that had been carried out in shop premises that were owned by XSRE, Pty Limited. XSRE put on an application trying to set aside the stat demand, and it raised a number of arguments. It said that the works had taken too long, that they had ultimately been charged twice what they thought they were going to be charged, and that they'd also suffered trading losses as a consequence of the delays. I think one of the problems that XSRE faced in that case was that its evidence wasn't particularly compelling, and essentially the judge in that case in the Supreme Court found that it really was just a bunch of assertions that were inconsistent really with the contemporaneous documents, the emails and different documents that were put into evidence. And ultimately, the court said that even though it was a fairly low bar to establish that there was a genuine offsetting claim, ex-SRE hadn't met that threshold in these circumstances. So essentially they were unsuccessful, and I'm not sure, based on the actual content of the decision, whether or not they were ultimately wound up or not, whether or not there was some payment that was made when they failed to set aside the statutory demand. But the case illustrates that there are some circumstances in which you will be able to issue a statutory demand. Really what you've got to think about before you go down that track is what the other side are likely to say in response to it, and whether or not they will have enough evidence to demonstrate to a court that there is some genuine offsetting claim that might offset some or all of the amount that you're seeking to enforce. So moving on from that then, Pat, do you want to talk about stays?
Yeah, sure thing. So as noted in the Supreme Court case, Grosvenor Constructions and Musico, a court can exercise the discretion to stay or to grant a stay of enforcement action pending a determination being made on an offsetting claim. This arises where interim rights under the Security Payment Act may become permanent rights. So as Matt mentioned, the object of the Act is to get people paid in the first instance, and then if need be, have a more detailed argument, I suppose, in court later. So, for example, if one party is on the brink of insolvency and they will be unlikely to be able to repay the funds if an offsetting claim is proven, then that may provide a basis for a stay, just to ensure that the money is not going to be lost if the offsetting claim proves to have legs.
Yeah, it used to be the case that a company in liquidation could make a payment claim, and that in some amendments that were made to the Act in October 19, that position changed. But before it changed, it was often the case that liquidators, for example, would issue payment claims or rely upon payment claims that had been issued and try to enforce those as judgments. And you'd have a situation where the other side would come along and say, well, I've got a claim that I want to bring against the company. There's all sorts of problems in me doing that now because the company's in liquidation. If I hand over this big amount of money, the chances of being able to recover that are remote. So it effectively, snookered parties in some circumstances. So, as you say, Pat, that case is one example of a situation where the court hit the pause button on the party's rights and allowed the respondent in that case to pursue its claim before having to hand over the money. So
you're right.
So you go ahead if you like.
Oh, I was just going. Yeah. Okay. So a big question that a lot of clients have is, well, once we get the determination, what shot do I have of challenging it? And it's not quite as straightforward as you might think. So adjudicators' determinations can generally only be challenged for jurisdictional error, which essentially means that an adjudicator can make mistakes in the course of a determination, provided that those mistakes are made in the course of their action in accordance with the Act. So as long as they've complied with their duties under the Act, there may be a factual error. However, a determination can be binding even though it may be based on an incorrect interpretation of the contract. The most common grounds for a challenge are that there's been some non-compliance with a requirement of the Act or a denial of procedural fairness. Big ones that are often raised are that there was actually no construction contract in place upon which the claim is or under which the claim is said to have been brought. There was no valid payment claim, including if there was no available date for the claim. Time limits have not under the Act, as we know. It's the time limits are very strict under the Security Payment Act. So that's often a common one raised to challenge an adjudication determination, or items that are not claimable under the Act.
So there can also be arguments about whether or not there's been a denial of procedural fairness, including, for example, if the adjudicator has denied a party the opportunity to make submissions on a particular point, or for example, if the adjudicator has gone off on a frolic of his or her own and taken into account matters that neither party has raised without giving the parties an opportunity to comment on them, and also situations where the adjudicator fails to comply with the statutory obligations that are set out in the Security of Payment Act itself. So a common sort of argument about denial of procedural fairness that you see is if there's some argument about the extent to which the respondent has addressed a particular point in a payment schedule, and whether, as an extension of that, they have a right to go on and make submissions about that in an adjudication response. You often see that pop up as an argument from a claimant about the fact that if they weren't put on notice of a particular point in a payment schedule and they didn't have an opportunity to properly consider it and address it in their application, that constitutes a denial of procedural fairness. So we won't sort of revisit the issues concerning payment schedules that have already been addressed in an earlier presentation, but it's crucial that if you're a respondent, you say everything that you want to say in opposition to the claim or as a reason for withholding payment in your payment schedule. If jurisdictional error has occurred, the court now under the Act has a discretion to set aside part of the determination as opposed to just setting aside or quashing the whole amount. So I think that's quite important, and it can avoid a situation where the whole determination comes crumbling down just because there's an error in a small component. So, for example, there was a case a couple of years ago in the Supreme Court, a year or so ago, where there was a sizable amount being claimed. It was at least a six-figure amount, and the adjudicator was held to have made a mistake over a small portion, sort of a $5,000 or $10,000 item that was being disputed. In that case, and under the Act now, the court has the ability to set aside that small component and otherwise leave the determination intact, which is, it makes sense from a practical point of view. If it's only a quite minor mistake, there's no reason to set aside the whole of the determination. Again, as I mentioned, in a situation where any respondent comes along and tries to set aside a judgment based on an adjudication determination, if someone wants to challenge the adjudication determination in court on a jurisdictional error or denial of procedural fairness basis, that generally they will be required to pay the amount of the determination into court, pending the outcome of that challenge.
So once you've got a determination, what happens to the rest of the rest of the relationship under the contract? Essentially, a determination will not permanently affect any rights a party has under the construction contract, any right to make a further progress claim under the Act, or any rights that the party has in outside of the Act in connection with the construction contract. The determination will also not prevent a party from commencing separate civil proceedings to exercise a right under the construction contract. The only exception being if a payment has been made pursuant to a determination, that must be taken into account in any proceedings that are brought, so to avoid double dipping, claiming the same amount in two separate ways.
Yeah, that's a really important aspect of the Act, and it's one way of sort of balancing the scales, if you like. Because the adjudications are sometimes rough and ready justice. As they've been described previously, including in court judgments, everything happens quickly. People are under time pressure. Sometimes mistakes can be made. If If a party does feel disgruntled at the end of the process, they always have the ability to commence proceedings in the ordinary way, and that's really sort of the trade-off for the ability on the part of the claimant to fast-track payment. They, on the flip side of that, a respondent may still be able to commence proceedings if they wish to in the ordinary course. So that's really all we wanted to cover this morning, but if there are any questions, please feel free to let us know by the hand raise function in Zoom, or if there's no questions now, but you guys think of something that you want to raise later on, if you have any question that you'd prefer to raise separately, obviously feel free to email us in that question. On Friday of this week at 2 p.m, we'll be having a final wrap-up session, sort of general sort of Q&A. So feel free to dial in at that time, raise the questions, or as I said, email them in advance. We can address them with you, including at that time. We'll just be sort of wrapping up and dealing with some common sort of questions that have popped up during the course of the series of presentations. We'll tell some war stories and recount some of the major issues that can pop up under the Act. So look, until then, thanks for joining us this morning. We appreciate your support, and we'll see you again 2 p.m. on Friday.
Thanks very much, everyone.